On behalf of SDGH3, I beg to mention item number 7 and 8 of today's stated list. I have the consent of the other side. Your Honor, she is suffering from acute pancreatitis actually, so she needs surgery. So she wouldn't be able to come for it. So Lordship may kindly pick the doctor for it. Lordship, in case of item number 8, the opposite party counsel, Shri Rajesh Majumdar, made a request that the date may be fixed after, even if our SCJ is not able to come, a date may be fixed after.
Your name, please.
P. Devi, but I am on behalf of SDGA.
As from
S.
7, you are there.
On
For a
behalf-
petitioner?
Yes.
Okay, Mr. H. Ms. P. Devi, Learned Counsel, appearing for MSS Sharma, Learned Standing Counsel, has submitted that MS Sharma is in this court and case be put after court. Learned Counsel for the present ground cited for adjournment. The prayer may not have been completely accepted. Is the court. Same Armada. Huh? Do it. Do it.
Item number 7, here it is.
SDGA
To accommodate.
I'm agreeing to the finance department, item 7.
Actually, there is no time.
Yes, diagonal.
Finance.
Yes, the Dr. Mr. R. Borpujari is out of station due to personal difficulty, not available today.
So who is making prayer for adjournment and in 7?
So finance department, there's an authority to mention.
Oh, 7 to 2. Mr. H. Petri.
Yes.
Learned Counsel for the petitioner. Who is for the state? H. Sharma. Learned Additional Senior Government Reporter. Number 1. Mr. Sharma, you are appearing.
Item number
Okay. Mr. N.K. Sharma representing Learned Counsel representing Mr. H. Keda. Learned Senior. What day? What day? 1, 2, 4. H. Sharma 1, 5. 1 and 5. 2, 4, 8. MS R.
RM Borwai.
RM Board. Learned Counsel representing Mr. R. Borpujari.
Borpujari.
Learned Standing Counsel. Finance Department. Order as per number 5. H. Sharma 1, 3 and 1, 3 and 6. 1, 3. And H. Sharma 2, 4, 8. Any Accountant General? After MS Borwa and number 5 has submitted that for the yes, after
2 weeks.
yes,
Yes.
Read it. After
May it please your lordship. My lord, I did to mention the listing, my lord. On Monday or any other day on next day.
what for what?
For order.
Monday not possible.
Any date, my lord. Next.
Court master.
May I
Yes.
please your lordship? With the consent of the other side, I beg to mention item number 11 of the daily report.
11.
Lordship. In this matter, Lordship, we have prepared the affidavit and sent it for vetting, Lordship. So it has come after a long time, Lordship. The situation name
17
has been
matter.
reflected.
Affidavit. No. 2017 matter. Affidavit of
Lordship,
right.
no, Lordship. On 24 past, on January, Lordship, our name has been reflected, Lordship.
Okay. Who is for the petitioner? Okay. MS SG Borua. Right. Counsel for the petitioner. Uh, H. Sharma. 1. H. Sharma. Representing H. 2. Huh? Dot, dot. Mr. Sharma. Appearing for current counsel for that. 2. Submitted that. The counter affidavit on behalf of the respondent number 2 is being prepared and the same will be filed within
Within 3 weeks, Lordship, it is
3 weeks time. So here's the date for listing of the case after 3 weeks. Here's the case after 3 weeks for filing of counter affidavit on behalf of the number
deeply appreciated.
May it please your lordship. Lordship, with regard to item number 9 and 10.
9 and 10.
Yes, your lordship. Lordship, the records are being missing from your lordship file.
Records are missed.
There are 2 affidavits which have been filed by the respondent as well as by the petitioner.
No, it was no. No, let us take item number
9 and 10, your lordship.
9.
9.
Now, what is missing?
Lordship,
9 is okay. That is
9 is
only-
okay.
Yes. Only 10 with regard to shared affidavit.
lordship, our affidavit has been filed on 23/1/2018, your lordship.
2018.
2018.
Have you pointed out anytime?
Copy to us.
Yes, we have given.
Have you pointed out to the court?
No, your lordship, today is the first time.
And how can you say that it is missing?
Because your lordship, on order dated 13/2/2018,
13 to
13/2/2018, if I may read your lordship, it is submitted at the bar that the cases are ready as regards pleading and can be taken up for final hearing and disposal. Item 10, your lordship.
item 10, it is of 2016.
16.
There is no such order. What date?
It has been passed in item number 9, I guess, your lordship.
9.
9. 13/2/2018.
13 to 2018.
My lord, in item number 9 also, they have filed it.
Now, in
13/10/2017.
item number 10,
10, your lordship.
now what is missing?
My
Or
lord,
what is not
affidavit in opposition.
part of the case record?
Yes, your lordship. Lordship. My lord, affidavit in opposition filed by the petitioner in item number 10, your lordship, and
Item number 10.
10.
Item number 10 is Northeastern Court.
Yes, your lordship.
Yes. There, affidavit in
Opposition filed by the petitioner. I filed by the respondent number 7, your lordship.
7.
7. That is missing, your lordship.
Did you file it or not?
Yes, your lordship. We have given them a copy also.
Yes, sir.
Copy given is one thing. Filing is another.
Yes, your lordship. We have filed it.
There is only an office note on 6/11/2023. Learned Counsel entered appearance on behalf of the respondent number 7 by filing Okalatnama. So your appearance in item number 10 is acknowledged only on 6/11/2023.
Yes, Your Lordship, earlier.
Earlier, there was another set of counsel, Your Lordship. We have been appeared in 2000, since 2023. We are appearing in this particular matter, Your Lordship. Lordship, in item number 9 also, they have filed it recently, but it was actually filed on 2000.
Now tell me, in item number 10, you want to say that
record-
respondent number 7 has filed an affidavit in opposition in the year 2000.
18.
Which month? Which month?
23/1/2018.
Okay. Who is the petitioner in item number 9?
Item number 9.
You are the petitioner.
We are the petition.
What is your name?
S. Gautam, Your Lordship.
S. Gautam. And you are respondent number
Uh,
7.
7. 7 in item number 10.
10. Okay.
Both the cases.
Mr. S. Gautam,
Yes, Your Lordship.
learned counsel for the petitioner in 9. And for the respondent number 7 in 10. And Mr. A.M. Doctor, learned
And
counsel
for
for the
respondent-
petitioner in 10.
Then in 9, we have put 3, 4, and 5.
And for the respondent number 3, 4, and 5
In item
in 9 are present. So Mr. Gautam, learned counsel has submitted that an affidavit in opposition for the respondent number 7 in 10 was filed in March,
23/1/2018.
in January 2018, and the state affidavit in opposition.
which is copied to us.
A copy by furnishing a copy to the learned counsel for the petition. But the state affidavit in opposition is not part of the case record of WBC number
2408.
2000. What is the other one in
Uh,
item number 19?
7173/2015.
What is missing?
Lordship, there
According-
is nothing is missing. They have
Nothing is missing.
refiled it, Your Lordship.
We
They have refiled it.
We refiled.
Refiled. Refiled. What is refiled?
The affidavit in
Okay.
opposition filed by them.
On 1, 4.
Now what do you want? Okay. Office to trace out the state affidavit in opposition and to take the same with the case record as sought for by the learning parties. Is the case up to it.
Lordship, a date may be
Date.
fixed.
It will be listed as per in series of 2015. It will be according due precedence.
May it please your lordship.
After 2 weeks, on date will
Lordship,
be
I
filed
beg
up.
to pray before,
Yes.
I beg to pray before lordship, listing this matter, lordship, for admission.
What is the matter?
Lordship, the matter pertains to violation of building rules. Thereafter, I have filed a complaint before the Goalpara Municipal Board. Thereafter, lordship, after issuance of the direction to the respondent authority, they did not follow up, lordship.
Bench 4 or bench 5?
Bench 4, lordship.
Bench 4. You are mentioning it before bench 5. I have seen cases mentioned in bench 4, listed in bench 5. Make a mention before the bench, proper bench.
I pray for listing of two writ petition, my lord, or motion, my lord, on Monday, my lord.
What is the subject matter?
Subject matter is, my lord, land acquisition.
Okay, next.
For motion item number 12,
Lordship, needful your lordship is allowing me to appear virtually, my lord. Am I audible, my lord?
Yes, yes.
Yes, my lord. My lord, the issue in the writ petition is that, my lord, the petitioner has against an audit,
Yes.
against the order issued by the respondent number 4, which was not supported by the summary of summary form GST DRC 07 has been The only humble prayer before this court by the petitioner is that, my lord, that the authorities are bound by the statutory provision to issue a summary of the order in DRC 07, my lord. My lord, yesterday I made I have already made the statement of fact, my lord. Only, my lord, today, my lord, I want your lordship to take up the annexure 6, my lord, which is at page 117, my lord, which is the instruction, subsequent instruction, my lord, page 117, my lord, of the writ petition. My lord, these instructions were issued by the board, my lord, considering the facts that the authorities, the CGS, particularly CGST authorities, are not following the statutory provision as prescribed under Rule 142, my lord. My lord, here, my lord, the board has categorically and specifically directed to issue the summary of show cause notice through portal and the summary of order through portal, along with the order, my lord. My lord, in the instant case, my lord, in my particular case, my lord, the authority has neither issued the show cause notice through portal nor issued the summary. Accordingly, even after issuing the order or sending the order through mail, they have not issued the same through portal, my lord. My lord,
Yes.
my lord, relevant paragraph is, my lord, paragraph 4 and 5 is page 118, my lord. The instructions, my lord. My lord, why these are required, my lord?
Paragraph.
Paragraph 4 and 5, my lord. My lord, may I read paragraph 4, my lord? It is highlighted that non-issuance of the summary of such notices and orders electronically on the portal is in clear violation of the explicit provision of the CGST rules. Besides, uploading the summary of notices and orders electronically on the portal not only makes the said notices and orders are available electronically to the taxpayers on the portal, but also helps in keeping a track of such proceedings and consequential action in respect of recovery, appeal, etc. subsequent track to issuance of such notices and orders. Accordingly, any deviation from this requirement under CGST rule may adversely impact record keeping under the GST. Further, such an action may also impact further proceedings of appeal and or recovery to be done seamlessly on the portal, my lord. Now, thereafter, my lord, the proper officer are accordingly directed to ensure that the summary of the notices issued under section 52 or section 73 or section 74 or section 122 or section 123 or section 124 or section 125 or section 127 or section 129 or section 130 of the CGST Act are served electronically on the portal in form GST DRC 01. Also, they should ensure that the summary of the order issued under such sections, my lord, I'm not referring the section, is uploaded electronically on the portal in form GST DRC 07. Thereafter, the principal chief commissioner, the jurisdictional head of the CGST.
Now, according to you, DRC 01 and DRC 07.
Yes, my lord.
Not uploaded.
Not uploaded, my lord, and accordingly, the orders were also show cause notice and the summary of order also is not uploaded in the portal, my lord. That is the common portal.
DRC 01 and DRC 07.
Yes, my lord.
These two are not uploaded.
My lord, the order is also not uploaded in the portal, my lord, because, my lord, since they have not issued the summary notice, my lord, show cause notice through portal,
No.
subsequent order is also not available in the portal, my lord.
DRC 01 and DRC 07. DRC 01 is summary of the notice.
Yes, my lord.
And DRC 07 is summary of the order
Yes, my lord.
issued under section 73.
My lord.
So, same thing. One
my
is DRC 01.
Yes, my lord.
If you read paragraph 5,
My lord.
DRC 01 is summary of the notice.
Yes, my lord.
As per sub-rule 1, rule
Yes,
142.
what 42, my lord?
Summary of the order should be in the form of DRC 07. According to you, these are not uploaded.
My lord, the orders are also not uploaded in the portal, my lord. Because the order or the show cause notice has to be uploaded along with these two, my lord. This order and the portal both are required to be uploaded, my lord.
Madam, come to paragraph 5.
My lord.
You are reading instructions, right? Paragraph 5,
Yes, my lord.
page 118.
My lord. My lord.
Don't go beyond the instruction. Paragraph 5 is summary of the notice and summary of the order.
Yes, my lord.
Let us stick to the clear language. Summary of the notice in DRC 01, paragraph 5,
Yes, my lord.
and summary of the order. It has not spoken about the order.
My lord,
Summary of the order.
yes, my lord. I bow down by your lordship's observation, my lord. Accordingly, my lord, the instruction starts with the issuance of notice and order, my lord. Paragraph 2 is also required, my lord. My lord, kindly see, my lord. It is also paragraph 2 at page 117, my lord. It is also mentioned that as per sub-rule 5 of rule 142, where any order is issued by the proper officer under such section, summary of such order is also required to be uploaded electronically on the portal by the proper officer, such and such, specifying the amount and demand and etc. My lord. My lord, why this instruction, my lord, has been issued at a very belated stage, my lord. My lord, kindly see the instruction were issued in the 23rd November 2023, my lord. My lord, why it come to the notice of the board, my lord, that they are not following the statutory compliances and making the portal, my lord, making a subsequent and consequential events the difficult to follow up, my lord. And my lord, the difficulty is today is that, my lord, if these are not being followed by the portal, my lord, I have to, I cannot go for the appeal filing, my lord, also. It will also make difficult, even, my lord, for the sake of argument, if I say, my lord, that the authority is not required to issue the summary of the order, my lord. My lord, but the order is supposed to be issued.
I am not saying that they are not required to issue.
Grateful, my lord. But, my lord, the
They are
order is
required to
also
issue.
in the portal, my
Now
lord.
we are in a repetition whether our extraordinary and discretionary jurisdiction is required to be exercised in such a case. That is the issue. I am
Yes.
not saying that these are not required to be issued. Those
Yes,
are
my lord.
to be issued. But
My lord,
question is about exercise of our
yes, my lord.
discretionary and extraordinary jurisdiction under Article 226 of the
Yes, my lord, that is why, my lord, the
That
wall
is
book,
what, when a proper procedure is laid down,
yes, my lord.
now whether they will really find difficulty in filing the appeal, Mr. Cal, summary maybe if we understand, it is a synopsis of whatever was contained in a notice as well as in the order. Summary may be that, say for example, it could be that paragraph 14 of the notice. It could be like that. That why it should not be. This is the summary. Similarly, it could be that the summary of the order could be paragraph 20. Now, there is no denial to the fact that this demand comes to cause notice was served upon them. They received it. They filed reply. Now, an order in original has been passed by the LGT conference. So this is one contention, that these instructions and Rule 142 has not been adhered to. And according to them, it is mandatory. And if I remember correctly, and if I have understood correctly, second one is that one assistant commissioner,
Yes, my lord.
Silsor Audit Circle, issued the demand cum show cause notice. And
order passed by assistant.
order has been passed by another assistant commissioner. One assistant commissioner
What is
had issued the demand cum show cause notice, and another assistant commissioner passed the order. Now, here, I don't think they have raised the authority and jurisdiction of an assistant commissioner to issue such demand notice or to pass the order as an adjudicating authority. What they are challenging is that one has issued the demand cum show cause notice and the order has been passed by another assistant commissioner.
It is permissible. Let's say the internal arrangement not affect anyway. Order passed by the authority is saying the proper,
No, proper officer is okay.
but there is a circular to that.
Proper, as per the mechanism, assistant commissioner has the power, authority, and jurisdiction to issue a show cause notice and to pass the order as an adjudicating authority. What they are contending is that one has issued the notice, another has passed the order. Is it correct,
Yes,
madam?
my lord. Yes, my lord.
If there are some arrangements just like DGGI, then think of the
No. Instances are there. What is the law?
lordship, there is an internal circular. I place before a lordship allow me some time. I place
And whatever this uploading,
lordship. They have not raised this plea either in their application or for that window. Once they have not taken this plea, lordship, another opportunity of appeal is there before them. They can fight. And lordship 104 amendment say
now whether these are uploaded or not uploaded?
not up.
Not uploaded.
Yes,
Admitted position.
yes, sir.
The order in original has also not been uploaded.
That is means they have received the original copy. Lordship may please to section 108. Procedure of appeal and
108. Yes.
Rule.
Rules.
Rule.
Rule. Yes, rule.
Appeal to the appellate authority 1. Appeal to the appellate authority under subsection 1 of section 107 shall be filed form PSP APL 01 along with relevant document either electronically or otherwise.
As may be
As may
notified.
be notified by the commissioner.
Now what is the as may be notified?
Then lordship a provisional acknowledgement shall be issued to the appellate authority. 2. The ground of the appeal and form the application as contained in form PSP APL shall be signed and mannered specified in Rule 20. Then the certified copy of the decision or order appeal against shall be submitted within 7 days of filing of the appeal under sub-rule 1. Then a final acknowledgement including appeal number shall be issued from form PSC APL 2 by the appellate authority or the officer authority by him. The motive this rule has not stated about what my amendment is. That unless it is there, they cannot file. Lordship recently
No, I don't know what is the mechanism of the portal. It is required to be filed either electronically or otherwise as may be notified by the commission. It is optional. Electronic is optional. What is the other mode? Physical or not?
if for direct then it means
Physical or not?
High Court has directed for
No. Direction is different thing. Otherwise notified by the commission.
I file make inquiry about the notification. Lordship recently Patna High Court regard to
No,
appeal
first let us understand the provision. What is
regarding
no,
notification.
if it is notified, suppose physical submission of appeal, filing of appeal
Sure.
is notified, then we do not have to go to any other decisions of the court.
File take up.
See, electronically is permissible, but that is optional. Otherwise, as may be notified by the commission.
I have to,
If it is physical submission of appeal is permissible and as notified by the commissioner, then there is no question of.
Yeah.
They cannot say that.
Sure.
And secondly, whether because of non-uploading of the summary in the portal, whether it will not be possible for them to file the appeal.
another point, Lordship, is to see, the order was passed on, that on the December 25th. There is limitation.
No, we are not into it.
No, Lordship,
No,
see
I
that,
am quite aware. We are not into it.
so this is a
We are not into it. They are preferring a writ petition instead of preferring an appeal. And they have not said anything about that aspect.
Yeah.
Why should we go into it?
No.
These
No.
two are the main planks of submissions we have to deal with.
Now they make a submission that they, since it was not DRT 1 and 7 and 1 and 7 was not
Whether it was not possible for them to prefer that.
they cannot
Oh.
place that notification.
It's not to be- It is available here. Actually,
I'll make in
we have taken up this case for disposal only.
on, maybe taken
That is why we listed, because there were 60 matters yesterday.
Lordship taken at 2 o'clock. Time I will make it, but it is there. I'll place.
There was no point keeping it pending.
Not-
If this way or that way.
Not-
If really because of that
Yes, sir.
non-uploading of the DRC 07 now at this stage. DRC 01 has passed. That
Yeah.
stage is passed. We'll
Already.
decide about that. But if the non-uploading of DRC 7 in the common portal
Not-
has made it impossible for them
To file a
to prefer appeal either electronically or otherwise as notified by the, then they have a good case.
probably this plea was also not get ready.
I have not seen the pleading, and for that I'll like for
My lord, may I assist my learned friend in this regard, my lord? There was a manual appeal filing notification was issued by the CBIC, my lord, the board in 2nd August 2023, my lord. But my lord, that manual appeal filing procedure was been laid down only to that extent that where the section 73 order or 74 order has been passed by disallowing the credit of transitional credit, my lord. Because my lord, that particular notification also deals with that in case of that any order under section 73(1) or 74 disallowing the transitional credit has been passed, the appellant is required, the registered taxpayer is required to file appeal manually, but no pre-deposit also required. That is also specified in the no pre-deposit, my lord. My lord, the pre-deposit for filing any appeal also has been waived for particularly for those appeal, my lord. My lord, not for the other cases, my lord. Section 73 and 74 regarding disallowance of transitional credit.
Tell me quickly about rule
Yes, ma'am.
1, sub-rule 1 of rule 108.
My lord.
Now, there is a provision either electronically or otherwise as may be notified by the commission.
Yes, ma'am.
Now, your submission is that non-uploading of DRC 7, right?
My lord, not only the DRC 7, my lord, the order also not uploading through portal, my lord. Actually, it will, my lord, what, my lord, seems.
Madam,
Yes, ma'am.
when I am asking a straight query,
My lord, grateful, my lord. I apologize, my lord.
then you should stick to it.
My lord.
Whether it is your case that non-uploading of DRC 07, that is summary of the order in original, has made it impossible for you to prefer an appeal.
No, my lord. That cannot be said, my lord. My lord, if the summary of order is not,
I have asked.
my lord,
Is what I have asked.
that is what, my lord. But my lord, the order, my lord, now, my lord, may I submit, my lord? My lord, now, my lord, if the order is also not uploaded in the portal, my lord, it will be it will make assessee difficult to go to the appellate authority, because who will be the appellate authority? That question also may come, my lord. Yeah, my lord. My lord, I cannot. I should be very, very
Yeah, come to 106 page. 106, madam.
Yes, my lord.
Para 2 B.
My lord.
There is no confusion about the appellate authority. Absolutely no confusion.
Grateful, my lord. Yes, my lord. That I can see.
That you cannot take. The additional stroke joint commissioner appeals, third floor GST Bhavan, Kedar Road, Machkua, Guwahati 781001, where such decision or order is passed by the deputy or assistant commissioner or superintendent. What more is required? Clarity. What clarity is required?
No, my lord. I can see that, my lord.
And
But then the
don't
only
take
question,
don't take
when,
such ground.
my lord, then, my lord, the only question remains that whether the
Wait for
DRC,
second paragraph. It is
my lord,
made clear who will
my
be
lord,
the appellate.
my lord.
And 4 is also clear.
Huh?
Those 4. Appellate authority under section 1 of section
That is what I have been asking. 108. Whether just I am asking that non-uploading of DRC 7 in a common port, whether it will make impossible for them to prefer the appeal either electronically or in other form. What are the other forms? That is what I am asking. That is the instruction. So far, say that it will not be, it is possible. Fairly submitted, it is possible. The question is, what is the implication of non-uploading of DRC 01 and DRC 07 in the common portal vis-a-vis Rule 142 of the GST? That is the issue. One. Second issue, that demand comes to notice was issued by one assistant commission and the order has been passed by another.
No.
I think in some substance, these are the main two planks of argument. Am I correct?
Yes, my lord. My lord, I must be candid with you, lordship. My lord, that's today also, my lord, if the DRC 07 is being or if anything is uploaded, my lord, that may not change the order, my lord. Your lordship observe that very, my lord. I bow down by your lordship's observation, my lord. My lord, only thing is that, my lord, this is for my understanding whether they can sustain with this order without following the statutory provision or not, my lord. Otherwise, my lord, in any circumstances regarding fact and other issues, my lord, my client is required to go to appeal, my lord. Yes.
This to entertain the writ petition under Article 56, you have to make out an exceptional case. That is a law.
Yes.
Now we have to find out whether you have made out an exceptional case or not. Otherwise, all grounds again will be open before the appellate authority.
My lord.
We have to your case whether you have been able to make out an exceptional case to entertain the writ petition.
My
That
lord,
is all.
in particular, my case, my lord, only the procedural irregularity is there, my lord. That is whether if that makes the writ petition amendable, my lord, that is only the procedural irregularity. Yes, my lord.
You have made your points clear.
My lord.
Credit. The instant retreat under seeking to invoke the extraordinary and discretionary restriction of this code under Article 226 of the Constitution is preferred to essay a demand come so cause notice bearing number is 18 issued under subsection 1 of section 70 of the Central Goods and Services Act, comma 2007 within bracket, the CPS, and an order in original bearing number 10 dated 14/12/2020 passed on passed under subsection 9 of section 73 of the CTS by the adjudicating authority. The petitioner hearing is a private limited company incorporated under the Companies Act 1956 and it carries on the business inter alia of service provider. So it has its registered office at Kolkata, West Bengal. So with the enactment of the CGST Act 2017 and Assam Goods and Services Tax Act 2017, WEF 0107/2017, the company, the petition company applied for registration under the CDEX and has been granted registration by Para GSEIN number on 1/8/2007. The petitioner company's petitioner company is assessed under the office of the respondent number 2, command technique, command number 2. So the petitioner company has asserted that it has been duly complying all statutory requirements under the CGST Act, SGST Act, by way of filing its statement of outward supply in GSTR and monthly returns in GSTR-DB till date. Madam Mukherjee, if I go factually wrong, please tell me. Factually wrong. Factually.
Yes.
Section 5 of Chapter 213 of the CGST 2007 has provided for audit as per section 65 of Chapter 213 has provided for audit by tax authority as per subsection 1 of section 65. Sub-rule 2 of Rule 101 of the Central Goods and Services Tax Rule 2007 has provided that where it is decided to undertake the audit of a registered person in accordance with the provisions of section 65, the proper officer shall a notice in Form GST ADT 01 in accordance with the provisions of subsection 3 of section 65. Full stop. Para. The petitioner company was served a notice on 30/11/2021 under Rule 101 of the CTST Rules 2007, informing that the books of accounts and records of the petitioner company for the period from July, 2017 to March, 2019 would be audited. No, sorry, like that. The petition company was served after carrying out conducting the audit of the records and books of accounts of the registered person, the proper officer, as per sub-rule 4 of Rule 101, is to inform the registered person of the discrepancies noticed, if any, as observed in the audit, and the said person may file his reply, and the proper officer shall finalize the findings of the audit after due observation of the reply part. So, the petitioner company was served after auditing of the after conducting the books of accounts and records of the petitioner company for the period from July 2007 to March 2009 to the extent available, the discrepancies observed in the course of audit was informed to the petitioner company by its audit observations by the notice, by the letter dated 30/11/2011 on the subject audit observation. So, after receipt of the letter dated 30/11/2000, after issuance of the letter dated 30/11/2021, the respondent number 3 issued a corrigendum to the audit observations dated 30/11/2021. Issued a corrigendum on 16th. In response to the audit observation of the respondent number 3, the petitioner company submitted its detailed reply on 30/12/2021, wherein the petitioner accepted some of the liabilities as noted in the audit observation and duly discharged the state liabilities voluntarily in Form GST DRC 07 03. What is the date of page 66?
Pardon, my lord.
Hmm?
My lord, DRC 03, my lord.
Page
Hello.
66, date.
My lord, page 58 onwards.
No, page 66, letter date.
Oh, my lord. My lord, the page 66 is the intimation of the final audit report, my lord. That
No,
is Form
date,
GST
date.
edit.
I am asking for the date.
1/9/2020.
Date, my lord. Date they have not mentioned here, my lord. My lord, we can retrieve the date, my lord, at the last page, which is at, my lord, page,
Just tell me the date. I am not asking for your submission, madam.
Page 87.
87, my lord. 1st September 2022, my lord.
That's all. I have asked for that.
My lord.
87. Subsection 6 of section 65 requires that on conclusion of audit, the proper officer shall, within the stipulated period, inform the registered person, whose records are audited, about the findings, his rights and obligations, and the reasons for such findings. Also, as per sub-rule 5 of Rule 101 of the CGST Rule 2017, on conclusion of audit, the proper officer shall inform the findings of audit to the registered person in accordance with the provisions of subsection 6 of section 65 in Form GST ADT -0. In the case in hand, the results, the findings of the audit in Form GST ADT 02 was served upon the petitioner company on 1/9/2020. As per subsection 7 of section 65. Where the audit conducted under subsection 1 results in deduction of tax not paid or got paid or erroneously refunded or input tax credit wrongly availed or utilized, the proper officer may initiate action under section 73 or section 74 of the CGST Act. after the issuance of after issuance of the form, comma, GST EDT 02 on 1/9. Are you correct? 1/9. 1/9. 1/9. 2020, comma, the the demand comes show cause notice. The impugned demand comes show cause notice stood issued to the petitioner, the demand comes show cause notice under subsection 1 of the CTS Act to the petitioner company to show cause as to why. To show cause before the
My lord, page 97, my lord. The reasons for issuing show cause notice. My lord.
then, madam, the other ground, second ground goes page 14, paragraph 14. It is very specific.
My lord, the paragraph 14, my lord, of the order, my lord, your lordship is referring paragraph 14, my lord.
Hmm.
My lord, the paragraph 14 does not say that by which means, my lord, the personal hearing notices has been issued to me, my lord, and before which authority.
As to why. As to why. It is 97, not 1, not 1. Para on receipt of the aforementioned demand comes to proceed, comma, the petitioner company submitted its reply to the so-called notice on 4/12/2020. It was thereafter, comma, the order in origin, heading number 7, came to be issued on 14/12/2020, holding inter alia.
My lord, it was sent to me by email, my lord, on December 29, 2023, my lord, 5 a.m., my lord, in the morning, my lord, page 105.
I have not come to the point of recording your submission, madam.
My lord, grateful, my lord. I oblige, oh, lord. That's the difficult, my lord.
Sir, when the court is dictating something,
My lord, I apologize, my lord.
did I committed a mistake in recording so and so, dated so and so, to the issued? I am not said when it was served. You received it. Uh, after to issued. Full stop. The adjudicating authority, after discussion and finding, comma, had proceeded to pass the following. Para. It is the para. It is the issuance of a demand come to cause notice. No, sorry, the aforementioned demand come to cause notice dated 22/9/2023 and the order in original dated 14/12/2023 have been assailed in the instant para. I have heard MS S. Mukherjee, learned counsel for the petitioner. Any settlement of this
Yes, Bulwa.
to virtual mode, comma, assisted by Mr. S.S. Moore, learned counsel for the petitioner, and Mr. S.P. Kyle, learned standing counsel, CGSP, for the reference number 2, 3, and 4. No CGSP. Yesterday we have heard MSK from, no, Mr. B. Chakraborty was there. He was not there. I have not seen him. MS Mukherjee, learned counsel for the petition, has submitted that the entire proceedings, right from the issuance of the demand come show cause notice till passing of the order in origin on declared eligibility 14/12/2020 have are initiated in view of non-compliance of the statutory contained in the ECS Act 2007 and the CCS comma 2007, comma more particularly the are in violation of the provision contained section or rule 142,
Rule 142, madam.
rule 1, rule 140 of the DCS rules 2007 by MS Mukherjee has further drawn attention to instruction number 04 stroke 2023 dated 23/11 to submit that neither the summary of notice issued under section 70(1) nor the summary of the order issued under section 70(9) of the CTS Act 2007 had been uploaded in the common portal, uploaded electronically in the portal in form GST ERC 0-01 form DST year 07 testing. In view of such violation of the statutory law of- which were which are required to be followed by the respondent authority. The neither the demand comes to cause nor the order in which it is sustained. The next strength of of an enterprise is to the effect that the demand comes to cause notice was issued by the one authority, but the order in origin dated 14/12/2023 has been passed by another authority. Also, such procedure adopted by the respondent authorities are in clear violation of the principles of natural justice. Also, and as such, both the demand comes to court notice and the order in origin it is doing are not sustainably law, and the same are liable to be set aside and quashed. Yes. Any other submission? Any other submission?
My lord, only thing is that, my lord, your lordship was referring to paragraph 14 of the order in original, my lord, which records that the personal hearing were accorded to me, allowed to me, my lord. My lord, my only submission is that, my lord, where it is not clear from the order in original which authority has taken the personal hearing, my lord.
MS Mukherjee has further submitted that the no personal hearing was afforded to the petition by the respondent authority before passing the impugned order in origin. So, there are four contracts, Mr. Cal Narendra Senegal has submitted that the instant petition under Article 226 of the Constitution of India is neither maintainable nor entertainable. Full stop. As there is a statutory remedy of appeal available to the petitioner under Section 107 of the CGST Act 2007, which all the grounds which are raised by the petitioner in the writ petition are available to be raised in the statutory appeal, can be raised in a statutory appeal, and as such, the instant writ petition is liable to be dismissed. It has been, he has submitted that it has been held by a catena, by a long line of decisions, that when an efficacious, alternate, an efficacious and alternate statutory remedy is available, comma, a writ petition can be preferred only in exceptional circumstances. Full stop. On the as regards the first limb of submission of the petition, comma, it is submitted by him that the petitioner in its reply had never raised that non uploading of the summary of the notice, non uh, up, summary of the notice on the portal has never raised. Thus, comma, it is not open for the petition to raise such ground in a writ petition. It is further submitted by him that even it is assumed that the summary of the order issued under section 73 between bracket 9 has not been uploaded electronically on the portal in form GST DRC 07, comma, since the petition has not denied about receipt of the order in original dated 14 to 2020, the same cannot be a ground to entertain the instant writ. It is further submitted by him that dates were fixed for personal hearing, but the petitioner company failed to attain on the scheduled dates for personal hearing on 3 of 4 occasions. 4 occasions. 4 occasions. Since the petitioner company did not avail had chosen not to appear for personal hearing on those 4 dates, comma, it is not open for the petitioner to contend that the demand cum show cause notice was issued by one authority and the order in origin has been passed by another authority. Yes, anything more? I have duly considered and have perused the material. brought on record by the petitioner. Okay. The events leading to the issuance of the impugned demand cum proposed notice under subsection 1 of section 73 of the CTST Act 2007 have already been outlined above. As per subsection 1 of section 7, comma, in the case in hand, comma, the demand cum proposed notice was issued by issued on issued on 22/09/2023 by the Assistant Commissioner by one S. Mukherjee, comma, Assistant Commissioner, Central Goods and Services Tax, comma, Silsor Audit Circle, comma, Silsor Audit Commissioner, page 99. Yes, 73 speaks of anything about what is the relevant rule to related to section 73?
My lord, 142 only, my lord.
140?
2, my lord.
142.
142 only.
Procedure is not laid down anywhere else.
No, my lord. My lord, because the chapter starts and the section starts with the.
Right. Anything about personal hearing?
My lord, only to that extent, my lord, it is not clear from the paragraph 14 that which authority has issued granted the personal hearing and.
Rule 142. Anything about personal hearing?
Yes, my lord, nothing, my lord. I cannot, today also, I am not in a position to say that whether any email to this extent has been sent or not.
No. Anything about personal hearing in Rule 142?
My lord, that personal hearing issue is being dealt under section 75, my lord. If I'm, section 75. Yes, my lord.
By 4.
75 is the appellate authority.
No, my lord, section 75, my lord, general provision relating to determination of tax, my lord.
This is appellate authority. Stay.
Section 75(4).
4, my lord, 75, 4, my lord, an opportunity of hearing shall be granted where a request received in writing from the chargeable and such, my lord, only.
কোনখিনিত? The representation, sorry, the reply to the show-cause notice. It is not the case of the petitioner that the demand comes show-cause notice dated 22/9/2023 was not served upon the petition. So, on receipt of the demand comes show-cause notice, copy of the demand comes show-cause notice dated when, comma, the petitioner company submitted its reply to the said show-cause notice after a period of more than 2 months. On 4/12/2023. Thereafter, commander order in origin was passed on 2009-2024. Rule 140 as the case of the petition, as the first theme of as the first count of the petition is based on Rule 140 of the CST command. It is apposite to refer to the Rule 1. And Rule 5 of 140. The streamer referred to need for deletion. Instruction number 4/2023-DS has been issued by the Central Board of Indirect Taxes and Customs, Ministry of Finance, Government of India, on the subject is 157, serving of the summary letter. The same instruction has been issued by the CB, what is that short form?
Central Board of
Short form. CB, Central Board of Indirect Tax.
CBIC, my lord, Central Board of
Yes.
Indirect Taxation, CBIC.
Noticing in view of the the CBIC, in view of the provisions contained inter alia in section 73 of the CGST 2017, now taking note of provisions inter alia contained in comma is of the view that non-issuance of the summary of notices stroke orders electronically on the portal would be in clear violation of the explicit provisions of the CGST rule. And the proper officers, the CBS, the proper officers have been accordingly directed to ensure that summary of the notices issued entirely under section 73 and the summary of the orders, summary of the sorry, summary of the notices and the summary of the orders issued under section 73 of the CGST Act are uploaded electronically on the portal in Form GST DRC 01 and Form GST DRC 07 respectively. Relevant the relevant excerpts of the instruction number 04 from 2023 as DST are noted here. Four and five, page 150. Yes, sir. Before dilating on the grounds ours in its liquidity, comma, it is approved to refer to on the issue, the appropriate deal on the issue, about issue on the circumstances when issue uh, about the situation when despite availability of an alternative application and application statutory remedy comma arithmetic under Article is to be entered. It is relevant to note that the order in original dated
14 December 2023, madam.
14. The CGST Act, chapter Romans 18 of the CGST Act 2017 contain the provisions for appeal and division as per subsection 1 of Section 7, any person agreed by any decision or order passed under the CGST Act or the SDST Act or by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the state decision or order is communicated to such person. The order in original passed in the case in hand on 14/12/2023 is available under subsection 1 of Section 7 of the CGST Act. The petition company, instead of preferring such an appeal, has preferred the instrument para. It is settled that availability of an alternative remedy does not always operate as a bar to the maintainability of a writ petition under Article 226 of the Constitution. Even if a writ petition is maintainable, the High Court, in its extraordinary and discretionary jurisdiction, may not enter in a writ petition. So, the distinct concepts of quote unquote maintainability and quote unquote entered inability have been succinctly explained by the Honorable Supreme Court of India in Messer Godrej Sara Limited versus the Excise and Taxation Officer, Assessing Authority and others, reported in 2023, 3 SCR 87. Does having regard to the distinct concept of maintainable and entertainability, there is no doubt that the instant repetition is maintainable. It is the issue here is that as to whether this repetition should be entered in or not? In after making a survey of a large number of visits on the line of high number of visits, especially in revenue stroke tax matter, the Honorable Supreme Court of India in the case titled Commissioner of Income Tax and Others, submitted a report in 2014 1603, has observed that it it will come back after 5 minutes.
Did,
The demand come to court is dated 22/9/2023. But the summary of the said demand come to court notice was not uploaded electronically on the portal in terms of the provisions contained in Rule 142. One, Rule 42, 1 bracket small a. Inform GST DR0. Similarly, the petition company has duly received a copy of the order in origin dated 14/12/2000, but the summary of the order passed issued under 70 section 61 of the CGST. It will give passed under section 73(9) has not been uploaded on the port inform GST DRC 07, right? The question, the issue is whether such non-uploading of the forms, that is DRC, GST DRC 0 and form GST DRC 07, 01 or 0, have put is sufficient enough to enter it. The sufficient enough to enter it, it despite availability of the statutory remedy of It is not in dispute. It is pertinent to note that at the receipt of the demand comes locals notice dated 22/9/2022, the petitioner company took ample time of more than 2 months to submit its reply to the demand comes locals notice, and it submitted such reply on 4/12/2022. The petitioner company in its reply has not did not make any whisper as regards non-compliance of the provisions of Rule 142 1A of the CGST Rule 2007. A summary of the notice required to be uploaded electronically in Form GST DRC 01 is nothing but a summary of the demand comes proposed notice issued under subsection 1 of section 70 of the CGST 2007. Meaning thereby, a summary, the summary of the notice does not contain anything more than what is what are what are mentioned in the demand comes proposed notice. Also, by not raising anything in its reply to the stakeholder notice, submitted for 2008, by the petitioner company, it has, by implication, appears to have waived such requirement. It is It is well settled in law that a mandatory provision of law is well settled in law that ordinarily, a mandatory provision of law requires strict compliance. But there are situations where even if a provision is mandatory, non-compliance would not result in nullification of the acts. Situations to accept. One of such situations to accept is that if a certain requirement or condition is provided in a statute for the benefit or interest of a particular person, the same can be waived by him if no public interest is found involved. The ultimate result could be valid if the requirement or condition is not performed. In Commissioner of Custom, Mumbai versus Vargo Steels, Bombay, and another, a point was raised to the effect that the notice required to be issued under section 28 within bracket as it stood then as it then bracket of the Customs Act 1960 was not issued to the respondent. It was contended that a notice under section 28 of the Customs Act 1962 was a condition precedent to invoke the jurisdiction of the officer concerned, and in the absence of such notice, proceedings initiated for the recovery of duty became void. It was contended that the principle of waiver did not apply to a mandatory requirement of law. It was contended by the department that the respondent company having expressly waived its right to receive a so-called notice, as also personal hearing would not be permitted to turn around and say non-issuance of notice under Section 28 of the Customs Act 1962 was fatal to the revenue. So the three judges bench in its judgment has held that while non-issuance of notice under Section 28 of the Customs Act 1962 may invalidate the procedure adopted by the proper officer under the Act, it will not take away the jurisdiction of the officer to initiate action for the purpose of recovery of the duty escape. A cumulative reading. It has been held that Section 20 only provides for the procedural aspect for recovery of duty, hence any irregularity committed by a proper officer in following the procedure laid down in Section 28 would not denude that officer of his jurisdiction to initiate for recovery of the escape duty. It only provides procedural aspect for recovery of. It has been held that even though a provision of law is mandatory, in its operation, if such provision is one which deals with the individual right of the person concerned and is for his benefit, the state person can always waive such right. Also, it has been held that the mandatory requirement of issuance of notice under Section 28 of the Customs Act 1960 is provided solely for the benefit of the individual concerned, full stop. Therefore, he can waive that right. The duty is just to issue a notice to the person concerned of the proposed action to be taken. Full stop. This is not in the nature of a public notice, nor any person other than the person against whom the proceedings are initiated has any right to such notice. Full stop. Thus, this right of notice being procedural to the person concerned, the same can be waived by that person. Full stop. Whereas in the decision in Padmini Sinha versus State of Assam and others reported in 2018, 10 SSC 561, is also in similar line. In the above background, uh, in the fact situation obtaining the case and following the principles laid down in the aforementioned petition, it can be safely held that the uploading of the summary of notice under Section 142(1)(a) inform DST DRC 01 and putting question. Summary of the state. Inform DST DRC 0 maybe a mandatory requirement but the same is not in the nature of a public notice. And such summary of notice or summary of state are only for the registered SSC and not for any other person. So, having not raising any issue in its reply to the stoker's notice dated 4/12/2023 on that aspect, this court is of the considered view that the petitioner has, by implication, waived the mandatory requirement, such mandatory requirement, which is exclusively for the benefit or interest of the petitioner and not for any other person. It is does not open for the petition to raise such a ground in a writ petition preferred, without availing the statutory remedy of appeal under 107. Coming to the on the next contention advanced on behalf of the petitioner is that the demand cum stoker's notice was issued by an assistant commission of Assistant Commissioner 1 Subhra Mukherjee, S. Mukherjee, Subhra Mukherjee, Page 9. Assistant Commissioner Central Shillong Audit Commission and the order in origin dated 14/12/2020 was passed by one Alok Kumar Vitsas, Assistant Commissioner Assistant Commissioner DST phase 10 Central in bracket goods and service tax bracket close Roman Central Excise Division Silchar Division Central Excise Silchar Division On perusal of the demand cum show cause notice, it is found that the petitioner notice was asked to call upon show cause before the Assistant Commissioner, Central Goods and Services Tax, Filter Division, Central Revenue Building, Circuit House, Filter, District Culture, Assam, 1578 within 30 days of the receipt of the notice. Full stop. It is found from the order in origin that it is recorded in the order in origin that personal hearing in the case was fixed on 23/11/2023 and 28/11/2023 respectively. But the petitioner it is further recorded that the petitioner failed to attend on those scheduled dates for personal hearing. Another date for personal hearing was fixed on 4/12/2023, but on that date also, it is recorded that on that date also the petitioner did not attend the personal hearing. Subsequently, a fresh date for personal hearing was given on 8/12/2000. The adjudicating authority in the order in original has further recorded that the petitioner again abstained from attending the personal hearing on 8/12/2023 and had sent an email letter dated 4/12/2023 on 7/12/2023, which, in fact, is the reply to the show cause. The learned counsel for the petitioner has, however, contended that no such notice fixing dates of personal hearing was served upon the petitioner assessing, and the said fact has been vehemently disputed by the learned standing counsel CGST. Full stop. The such claim and counterclaim are claim raising disputes on the factual aspects are not required to be decided in the re-jurisdiction, as determination of determination of disputed questions of facts. As a statutory appeal is considered to be continuation of the original proceedings, determination of disputed questions of fact would fall within the province of the appellate authority. The appellate authority has the has the jurisdiction, has the jurisdiction to decide both on the facts, both on facts as well as in law. Full stop. The petitioner has not been able to make out any case, make out the instant case, which that make out in such in view of such disputed questions of fact, comma, no, the petitioner, it is not a pleaded case of the petition in the instant petition that the petitioner assessee had asked for affording an opportunity of personal hearing after receipt of the demand come show cause notice dated 22/9/2000. In such obtaining fact, in such fact situation, obtaining the case, comma, more particularly in view of disputed questions of fact as regards received service of notice for personal hearing or non-receipt of notice for personal hearing, comma, it is not a case which can be straightly said to have fallen within the principle within the fundament, within the principle of law, comma, quote, one who hears must decide the case, unquote. Only. It is a contention of the respondent authorities that the petitioner assessee has failed to avail themselves the opportunity of personal hearing and left the case to be decided by the adjudicating authority on the basis of the written reply to the so-called notice dated 4/12/2000. One who hears must decide it. What are the other contention? Any other?
So eight, the directory. But earlier it was what sale was used, but it was 2020 was emitted. One A, the proper officer may create it was same.
Hmm?
One A.
I'm holding to 2022. This
2020,
is
2022 it was
which part? Which one?
142 capital A. 1 capital
1A.
it was A word was it was a
My lord, that is a pre-show cause notice, my lord.
That is pre
Pre-show cause notice, my lord.
here with concerned with 1, small a and small b.
My lord, the pre-show cause notice also not sent, but my lord, I have not taken that. Because since it is a may, my lord, the clause may.
In view of the discussion made above and for the regions assigned herein, this court is of the unhesitant view that the petitioner has not been able to meet out any exceptional case for interference in the extraordinary and discretionary jurisdiction of this court to interfere with the demand comes to cause notice dated so and so and the order in original dated so and so in its extraordinary and discretionary jurisdiction under Article 226 of the Constitution. In such view of the matter, this court has found that the instant writ petition is not to be entertained. So it is accordingly held to para. Non-entertainment of the writ, it is further, it is clarified that non-entertainment of the writ petition would not preclude the writ petitioner to raise. No, it is observed that the it is further. It is observed that the observations made herein above are only for the purpose only for the purpose as to whether the writ petition is to be entertained or not. So it is verified that non-entertainment of the writ petition shall not preclude the writ petitioner to raise all contention on fact and law before the statutory appellate authority, and none of the observations made herein shall be construed to be observations on merits.
My lord, only, my lord, the prayer is, my lord, the limitation for filing of appeal, my lord. My lord, if your lordship, may I pray, my lord, that if I file the appeal today, my lord, since 3 months has already been passed, my lord, the limitation of filing appeal, my lord, this point.
You are not raised. Actually, that might be the ground. You have raised all these grounds. What to do?
My lord, the limitation, my lord, the appeal, my lord, today, my lord, from that limitation should be counted from today, my lord, only.
Taking into consideration, you have filed a writ petition very day before yesterday, perhaps. I have decided that keeping that thing into mind.
My lord, I have filed the writ petition, my lord.
Anything on law?
My
I'll
lord,
observe accordingly.
my lord, pardon, my lord, I could not follow you.
Mukherjee,
Yes, my lord.
anything on law, I'll observe accordingly.
My lord, that only submission is, my lord, that, my lord, if I today file the appeal, my lord, I will be filing the appeal, my lord, since, my lord, I could not make out a case, my lord. My lord, the filing of appeal, my lord, within 3 months, my lord, from the date of receipt of the order. Matlab that only that much prior I am paying, my lord, that the period of
Appeal, statutory appeal
yes.
under section 107 of the CGST Act, the appellate authority shall take into account the factum of preferring the preferring the instant writ petition while considering the issue of limitation.
Grateful, my lord. Much obliged. Grateful, my lord.
Lordship has heard this matter on 19-2. 19-2 order.
Long back to 3 months, I
No,
have
19-2
I don't
order.
have that
Lordship,
storage
kindly have-
capacity, Mr. Doctor.
19-2 order, kindly have a look.
Or 92 order.
Yes.
Now, where is the impugned order?
Impugned order is page 67. Your Lordship.
Who is this Patadar Pavojan Tea Company Limited?
We after the company's petition, Lordship, it's mutated in our name.
You know, Patadar here is in the impugned order. Pavojan Patadar is Pavojan Tea
It's
Company
wrongly
Limited.
written, Your Lordship. Because as per the ATC order,
ATC order, which one is there?
yes, Lordship has find in page 65. The entire land of Daidam Tea Estate mutated in the name of the petitioner company,
Hmm?
including this. Lordship has
Yes, you want to say anything, Mr. Tal?
Lordship, I have
Can be shortcutted or what?
minor, will have to file it because the land is not in their possession. It has been
Possession is one thing,
Let's
okay, you,
admit it.
no.
Let's admit.
Lordship, we'll have to file it.
No, how this page 65? Let us see your page.
Lordship, kindly have a look at order dated 20th of February 2015. Page 60. I am concerning to Daidam Tea.
Hmm?
Daidam Tea Estate.
Now, why this Papojan Tea Company Limited?
That
Because
is in the wrong.
Mr.
It-
Dr. Rajaf, I
yes.
want to know clearly.
Yes.
Because Papojan Tea Company Limited, it means it is a juristic entity.
Yes. No, that company merged with.
Where is that?
That is not here because it's the earlier history, not disputed.
No, don't, not
We-
dispute.
we are-
Who will dispute?
No.
I do not dispute.
No, nobody
No.
has disputed.
Well, firstly, you have to
Company
bring on
petition-
record what is
No. We company petition orders we have.
no
annexed.
company petition. I think I have marked here.
Yes,
is-
yes.
But
yes.
the question is Papojan Tea Company Limited is nowhere.
Now, this 70 company, Your Lordship, but this order, the 70 company, the Tea Estate, that goes to Jamswar.
Oh, whether Papojan is appearing, Papojan Tea Company
That
Limited,
name is not appearing therein.
where? Because see, Papojan Tea Company Limited is a juristic and corporate entity, if it is limited. Where is that?
That we have not mentioned yet.
How? Because this has to be tested on that.
No.
Suppose Papojan Tea Company has been merged with you. Where is the document?
That Yeah, 1 minute.
Just because this has to be streamlined, right?
Otherwise, what I like to submit, Lordship, that the patta number, that the grain number, that everything has been.
Right, but this man,
That I understand. That
this man has mentioned about Pahojan Tea Company.
Lordship has kindly have a look at paragraph 4 of our DPT. We are not annexed, but we have made a statement.
Whether you annex is kind of big deal. It is not 1 bigha, something more than 200 bigha.
But that
Where is the
no, no,
document?
but the title is not disputed, Your Lordship. Here.
No,
Only
no,
the
no, that
question
is not. Sometimes I will not like to, if there is somebody like Pahojan Tea Company is in, this order is maintained, this is not affecting you.
No, Lord,
Until and unless you show me by
the notice has been issued to the Daidam TST. In order to
page 67, see, it is ordered that the name of the existing Patadar Pahojan Tea Company Limited
Yes.
against the schedule mentioned be struck off. Somebody has redlined from the register of records with immediate effect. Right?
Yes.
So this is Pahojan. And we are Warren and some brother of Warren.
Yes.
Who is Pahojan? How to link it?
Yes, I understand.
If you link it, then it is you have a good case. But
No,
if
then
you link
absolutely we have, but we have not annexed.
it,
But
you have
otherwise,
annexed.
how we run the TST, Your Lordship.
No, otherwise, no, we are on the basis of document,
No.
right?
May I request Your Lordship to have kindly have a look at page 52.
1 minute before
That-
that, let
that
me have, let
also
me
Lord-
have 1 minute before
Another
that,
day, Lordship have a look.
before that, let me have a look for the instruction contained. Good. Do you have anything whereby that Pahojan Tea Company
So,
name has
Lordship,
been
kindly have a
struck?
look at of the High Court order, page 52. Because the village name is Pabojan and
No.
the estate name is Daidam TST.
Right.
Page
Question is,
52.
this order mentioned about Pahojan Tea Company.
I understand. That is our sister concern. That
Show me by a
That has been
document,
marked.
that's all.
Okay.
Otherwise, they have also raised something in their era-wise comment. Better you clarify. That's all. Other issues regarding
position on,
provisions of law.
yes, absolutely.
Once this cloud is cleared,
Lord.
it can be disposed of.
Lord.
Am I clear?
Yes.
But otherwise, this order mentioned about Pahojan Tea Company.
That's the
Had
query.
it been only Pahojan Tea Estate,
Right.
okay,
But this the company's name is there.
somebody corporate entity,
Yes.
and I
I would like to claim.
I do not want to ignore that.
Yes.
That is all. Only issue that.
No.
Whatever is there, I have seen it.
No.
It can be disposed of.
Okay.
Within 1 week, you file or what? Mr.
Yes, that I clarify on tomorrow itself, Your Lordship, that if that part is
You require some time. Yes,
then
what?
there is only contention that the position is there. Our High Court's judgment, Bagaria is very clear.
That kind of thing, they have to fight by because we lost.
No, you can please then.
Okay. This can be decided on the basis of instructions also. If you want to file it, you can file it very short because last opportunity was granted.
Yes, 19-4.
This has to be fast. Final approach. So this has to be short. Any affidavit you require to file, this has to be very short. Anvi? We'll fix it then. Meantime, Mr. Tekka, submit verifying
Yes.
how Pavojan TSA company has merged with you
With the GEMS.
on the basis of land documents or whatever company
Yes.
petition, whatever. To support paragraph 4.
Yes.
Okay. Agree on a date.
Any day, your lordship, because it's an urgent matter. I have to dispose of money. We are like to have
Yes, Mr. Taludar, it is also
Yeah,
for him
yeah.
also. Any date means I can fix
Because
it tomorrow.
tomorrow.
No, it is up to you. No, he has to
Oh,
file an affidavit, somebody from
He
deputy
is the
commissioner.
operational lawyer.
So
No, I
you
may
take
join
a
with the
date
DC also
after
now,
10 days, fix a date, agree on a date
10 days.
after 10 days.
कितने में?
I think it is.
24.
Material after not period.
5th of June, your lordship.
Okay,
Fifth
good
of-
enough.
Yeah.
Third, Mr. B. Dr. Learned, Senior Counsel, assisted by Mr. S. Tekka, Learned Counsel for the petitioner, and Mr. B. J. Taludar, Learned Senior Counsel, assisted by MS. P. Devi, Learned Counsel for the all the respondents. Okay. Respondent 2, 3, and 4. Mazat A. Porter says he was sending out petition partner, but respondent number 1.
210.
Good stuff. The petition site has paid for a short accommodation to bring on record the relationship between Messrs. Pavojan Tea Company
Company.
Limited and the petitioner company and what is your sister company
Warren.
and
Warren.
Messrs. Warren Tea Company by way of an additional fee. By way of additional Mr. Taludar has submitted that he has received the pair-wise comments to file the counter affidavit on behalf of the respondent number 2, 3, and 4, and the same will be filed within 10 days time. So, he has just paid for listing of the case after 10 days. As list the case of on 5/6/2024 for filing of the pleadings,
Before that,
aforementioned
we
pleadings,
may exchange the pleadings, your lordship.
aforementioned pleadings. Good stuff. We have all that.
No.
You file?
Yes.
This side.
Get good.
Oh, I did it. Take this one back.
Ever.
2.
Your lordship, this matter was fixed for final disposal, but in the meantime, this matter has been now fixed for final disposal before the Supreme Court also. The issue involved is that a person interested, can he appoint an arbitrator? Here is the case of the general manager of the railway. So the issue before the Supreme Court is also whether the general manager, who is the interested party to the dispute, can he appoint an arbitrator? There are
This is
conflicts-
railway.
this is the railway.
The railway, 1 3-judge bench is there.
Now it's pending before the 5 judge.
And that is doubted by another 3-judge bench.
Judge ban. They have referred.
Now, what is the law
The law,
in
as
such situation?
Your Lordship, there is another judgment in the meantime, given by the Chief Justice itself. This is the judgment of, not in the case of railway.
No, we are concerned with railway. One, three judges bench had rendered its views as regards clause 63 or something retired, something like that, if I remember correctly.
Yes.
Then that has been doubted by a short order of another three judges.
Bench.
Now, issue is before a larger bench.
Larger bench.
Now, in such obtaining situation, what is to be done by the High Court?
I think it should keep the matter.
No, I don't think.
Your Lordship can always decide. Decide it on merit and then.
Yes, let us decide. We'll follow the law
Yes.
laid by the Supreme Court that when a matter is pending before the Supreme Court, one decision is holding the field, and that is doubted by another coordinate bench of same strength. What a High Court should do? That is the issue.
That's another issue. And
One of the issue.
one of
I think
but
I'm
in the
quite clear
meantime-
about that.
in the meantime, another three judge bench, not in the case of a railway, but on the same issue, whether an interested party can appoint a petitioner. Three
But
judge bench has
here
said-
it is 64.
Here it is 64, but
And what is the decision? I think somewhere central organized railway
it's central.
rectification. And what are the other one? Doubting
Uh,
it,
Tantia,
Satya. That's all.
and now there is
Now it
another,
is your call. I am ready.
uh,
We are anyway.
can it be taken up then in another day?
Timing.
You will come.
At 2 or it is up to you.
Can it be taken on some other day? Because- Let it be taken up on some other day.
Okay. On the conjoined prayer of Mr. D. Hanapati, Land Council for the. What is I? I?
I not been assessed praise on the last occasion. Kept pending, but
And read petitioner and MS
Eight Sharma.
A. Sharma,
On behalf of
Learned Council appearing on behalf of B. Chakravarti, Learned Standing Council, CGC, Learned Central Government Council, for the respondent Railway Authority. Okay. The matter stands adjourned for a week or even fixed date,
fixed date, 4th of June
4th of June.
is Tuesday. Or 18th of June.
Whatever you want.
18th of June.
Then we will not fix after 2 weeks. We are not going to.
4th of June.
Otherwise, I would have
4th
taken
of
up.
June then. 4th of
4th of. Yes.
Last week of June, because of model code of conduct, there are some decisions also taken by. So the government is not in a position to take that. That is what I have talked to the senior counsel. I have talked to the senior counsel. He agreed.
Okay. Miss S. Setia. Setia?
Yeah.
Learned Council for the petition. And Mr. Ardhor, Learned Council for the respondents are present. Mr. Hor has submitted that due to continuance of the model code of conduct, the final he has not been able to obtain a instructions as regards the decision of the cabinet subcommittee. So on that ground, he has got listing of the cases in the last week of June 2024. So, here, no objection, proceed here. So, these are the cases in the on a date in the last week of June. To be is better. Second, no, no. Who made it?
May I submit? Lordship, the Water Resource Department has constructed embankment,
This is a bench 4 matter or bench 5 matter?
land acquisition,
Right. You have brought it by order, making a mention before bench 4.
yes.
Why you have not followed the prescribed procedure?
On that day, when I mentioned before the concerned bench, then the question was raised and the court muster suggested that it is a bench.
This is not right, actually. You have brought it by order, making a mention before bench 5, making a mention before bench 4.
Men-
This is not the prescribed procedure. It ought to have been mentioned before the prescribed roster. Anyway,
I apologize for
that is not the proper one.
because it happened because of not because of my negligence.
Knowing
lack of
fully well
knowledge.
that it is bench 5 matter, why you have mentioned before bench 4? When bench 4, 5 is regularly sitting,
No, it is
that too on a hearing date.
it happened because of my negligence, Lordship. Not negligence, because of lack of my knowledge, maybe.
No, Mr. Mozumdar, you are a seasoned counsel. It is not that you don't know what is the roster of bench 4 and what is the roster of bench 5. Making a mention before bench 4 about a bench 5 matter, getting it listed, this is not right. Anyway,
I apologize sincerely for
court
Lordship.
takes notice of it.
Yes.
I know what I have granted, but I have not granted. Anyway,
Lordship, the issue is that I'm the owner of a plot of land on which the Water Resource Department has constructed embankment, and while constructing, they have acquired land without following the due process of law. Neither the land acquisition process is completed as per the law, nor the compensation is awarded to me. When the matter is raised before this honorable court, after getting notice from the court, they have informed me that work was in urgent nature. So at the time of construction, the land was not acquired. Now they have requested the circle officer of the concerned area to initiate the land acquisition process, which is a part of my, this communication is a part of my affidavit in reply, Lordship. You will find it in the page number 4.
page number?
Page number 4 of my, sorry, it is not running page. Affidavit in reply.
Yes.
Lordship, may I have a permission to read very small paragraph?
Yes. I have Great.
So, Lordship, this my prayer is very submission is very simple, that this petition may be disposed in accordance with the communication, directing the circle officer to initiate the land acquisition process and to complete the site within a stipulated period of time and avoid compensation in accordance with the provision of law.
Circle officer is not empowered to initiate any land acquisition proceeding. It is the government in the revenue department who is empowered. Any direction is to be given to the revenue department.
Here the letter is addressed, the executive
Letter is
engineer,
addressed by the executive engineer to the circle officer.
circle officer.
But circle officer is not empowered under the law to initiate any
only
land
the
acquisition process.
additional deputy commissioner.
No, two affidavits are filed. District commissioner has filed an affidavit.
Time for water report.
Which department has constructed?
Water resource.
When it was constructed?
It was constructed in 2021.
2020.
It is a typological error. They have given 2012, but there is a series of documents. It is a part of their affidavit in opposition to it was constructed in 2020.
Who represents Water Resource Division? Have you filed any evidence?
Not very the time.
Lord,
Evidently, on a part of the land belonging to the petitioner, construction was made. So, it is part of a project of the water. Under some project of 2011, 2012. Now, two things. It has been either constructed forcefully, and there is another thing in page 40, Park officer is reporting that the people of the landowners voluntarily allowed construction of the embankment voluntarily. There are two things, either forcefully or voluntarily. If voluntarily their consent is to be obtained. Otherwise, if there is no consent, then you have to exploit the land. And the case is not that 2021, it is a case of 2011-12. It is a project of 2011-12 that used to know FMP, some project. It is not your FMP, series of litigations. It is not. Who is the respondent? Water resource.
Respondent number 6.
He is not the proper authority, Mr. Mojumdar. You should complete the secretary commissioner who can represent the department. He cannot represent the department. Mojumdar. To want money for the acquisition, you need to impede the government. And government is represented by the secretary. Then only we can direct. We cannot direct an authority who is not empowered. The executive engineer, water resources, I don't think he is an authority
yes,
to represent the state. I think secretary, the department should be implemented, chief engineer should be implemented so that the proceeding can be brought to a logical conclusion. It's up to you.
amended title, I may be allowed.
Better you amend the special secretary or secretary commissioner, the department and chief engineer, water resources, if they are available. They are available. Then they should be implemented.
Yes,
It is established that water resources department had constructed the project on your land. Now it is established. File an appropriate application, not being implement.
Yes.
Otherwise, it's difficult. This is my point of view. I don't.
I look like.
Otherwise, we cannot bring the government. It is the government who can. Executive engineer is writing letters to initiate acquisition process, and decision has to be taken by the chief engineer and the secretary of the department. They can give you money. It will be writing letter. Better, it is up to you.
Liberty may be given to file a impeachment.
Liberty is always available. I think you file appropriate petition. Mr. Hart, they have been revenue. Here on. I think on MS M4. And Mr. Anupaita. And Mr.
T. Sharma.
Sharma. correct. In order to enabling file. Yeah.
Seniorism lakes praying for time being Lord.
Hmm?
Seniorism lake. I on behalf of MK Sud.
And madam, it's the last item.
He's coming. He's in another court number 7.
Can you start?
What?
Can you start? Otherwise, you cannot sit looking at the file. Yes, Mr. Talker, anything? Data?
Okay. Take it back. The pair was to hand over one TSK.
The question is, you ask for time to obtain
Right.
up-to-date report of Sunapur police station case number.
So Sonapur PS case
Ah.
number 134 that has been handed over
CBI. And what about 135?
135 will be the 134 is the main.
Sorry.
Now, a report is there so far as regards Sonapur police station case number 134, 2009.
Yes, ma'am.
That investigation of that case has been handed over to the CBI.
Well, that was my prayer, ma'am.
Already, 2018.
The matter has been coming again and again. It was not pointed out.
No, I have the report of our side. Order of the governor notification is enclosed. Look at the document yourself.
It's about that, my lord, your lordship.
Turn over the leaf, the net notification.
One 134. My lord, in the repetition, there are two prayers primarily. May I get a copy of?
No, Mr. Talda, please facilitate.
One is, my lord, what happened, my lord, the murder took place and the laboratory of the petitioner was ransacked in presence of the police. And my lord, almost everything of the laboratory was smashed. I am asking for a compensation, but perhaps, my lord, I cannot pray that before your lordship because assessment of the compensation will be difficult. What I pray for is that your lordship will give us liberty to approach the appropriate court, that is civil court. Otherwise, my lord, I was prepared to satisfy your lordship that without the consent of the state government, the High Court is empowered to direct CBI inquiry. So that is not required.
Already 6 years back.
It has been. So that will perhaps, my lord, with that observation, your lordship may close the bit.
Insofar as other two cases are concerned, 135, 2009, and CID
Charge has been filed.
already charges have been
Yes,
started.
yes.
So you have to take recourse there.
Yes. Because, my lord, I think in the earlier affidavit, my lord, they have stated that, my lord, charge sheet has been filed in both. The CID case is, my lord, in respect of the investigating officer, my lord, who had made the evidence detect.
But I think before a trial court, you will have remedy. Or trial court could have now that direct, if required, further investigation, whatever is there. So your prayer was handing over investigation of 3 cases. Out of that, after completion, 2 cases have been charged. Insofar as the third case is concerned, that has already been handed over to the CBI. So far as the claim regarding adequate compensation for damage in loss is concerned, so we can only observe that petitioner will be at liberty to seek as the process, as the same would require assessment of damage.
My lord, without that observation, my lord, my civil suit will be time.
Petitioner will be at liberty. That we can observe.
Yes.
Document. Part Mr. M.K. Freelance, MS, and Talukder. Dr. Lanet Council for the petition. And Mr. P.J. Talukder, by PJB Lanet Council for all that. The petitioner has instituted the instant writ petition and Article 26 of the Constitution of India, seeking mainly 2 reliefs. Colon dot F. Firstly, comma, a direction to the respondent status to hand over the investigation of 3 cases. A. Unapur Police Station case number 134/2009. B. Unapur Police Station case number 135/2009. And CID Police Station case number 18/2012 to the Central Bureau of Investigation, CBI. Secondly, comma, a direction to the state respondent to pay adequate compensation to the petitioners for the damages and for the damage and loss suffered by them due to the incident stated to have occurred on 15/12/2019 at the Hill City, Heart City. Para. Insofar as the two cases, Punapur Police Station, case number 135/2008, and CID Police Station, case number 18/2000, it has been submitted on behalf of the state respondent that after completion of investigation of the said cases, searches have already been filed in both the cases under Section 172 CID. Para. Mr. Taludar, learned senior counsel appearing for the state has placed a copy of a notification bearing number so and so is before the court, copy of a notification bearing number so and so, second, dated 16/5/2018 of the Home and Political within a department, Government of Assam. As per the state notification, the state government in the Home and Political Department, in pursuance of the provision of Section 6 of the Delhi Special Police Establishment, and after the Governor of Assam had accorded sanction the investigation of the case, Sonapur Police Station case number 134/2009, registered for the offences under Section 302, 201, 150B, 34, Indian Penal Code regarding killing of 6 persons of a family within bracket called Jogdol massacre, bracket close, and any other offences, attempts, abatement, and conspiracy in relation to or in connection with the above mentioned offense, and any other offences committed in the course of same transaction arising out of the same facts and simultaneously launching criminal have been handed over to the Central Bureau of Investigation. Mr. Taludar is to submitted that he will furnish a copy of the state notification to the learned senior counsel for the petition during the course of the Mr. Chowdhury, senior counsel petition has submitted that in view of submission of the charge sheet in the two cases, 135/2009 or CID and handing over of the investigation of Sonapur Police Station case number 135 of 2009 and any other offense or offenses committed in the course of same transaction to the Federal Bureau of Investigation by the notification dated 16/5/2018, comma, the relief sought for appears to be effectively redressed. Yes, I have submitted that the issue of assessment of issue of paying adequate compensation to the petitioner for the damage and loss caused due to the incident that occurred on 15/12/2009 would remain. Yes, however, fairly submitted that the issue
that should come from your
fair. Uh, with regard on as regards the payment of adequate compensation to the petitioner for suffering damage and loss, comma, if any, caused due to the incident that occurred that stated to have occurred on 15/12/2009. The court is of the view that same would require assessment they would require a detailed
reading of evidence
assessment and determination of questions of fact, and the same would require leading of evidence in a trial before an appropriate forum, and the read proceeding appears to be not a proper proceeding to decide such issue. In such view of the matter, comma, in the above fact situation, and considering the fact that considering the present status of the investigation trial of the aforementioned three cases, this court is of the considered view that the grievances of the petitioner in respect of the three cases mentioned here in above have been effectively replaced. So far as the issue regarding claim for compensation, the petitioners would be at liberty to approach appropriate forum in accordance with the a copy of the notification bearing number 22. Court master will give take 2 copies. One will be handed over to a copy of the notification so raised by Mr. Taluka today, is to be kept with the case. এটা ৰাখি